hello everybody. Thank you very much for joining us. My name is Jie Huang. I am a senior associate at Scott Legal PC. So today we are going to spend some time talking about several visa options available for individuals of extraordinary ability in their fields. So just a few things before we get started. So Scott Legal is a full-service immigration law firm, which means we assist individuals pursuing various types of visas. Our main specialty is assisting entrepreneurs and investors, but we do also process a wide variety of visas and green cards suited for various circumstances, including both family-based and employment-based categories. We will be continuing this webinar series, doing at least 2 webinars a month on different immigration law topics. At the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will also send you a comprehensive guide for all of the visa categories mentioned in this webinar that you can use as a reference. Third, we will also send you a link to where you can follow to sign up for additional webinars in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel because we do regularly upload immigration law related videos, not only the copies of the webinars, but also on a variety of different topics. Finally, we will also send you a link where you can follow to set up a consultation with one of our experienced lawyers should you wish to discuss your case further. So today we are very lucky to have Kelly Wiener, managing attorney at the firm with a wealth of visa experience, who will be presenting about the various visa categories available to individuals with extraordinary ability and the requirements and considerations. Finally, for any questions you may have, please do feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jie. All right, so I think we'll get started by just talking a little bit about kind of what are the extraordinary ability categories. So we've, listed, kind of the common ones here. So, first we have kind of the O-1A visa. So this is a non-immigrant visa, meaning it's a temporary visa, so not a green card, that is available for people who have extraordinary ability in the sciences, education, business, or athletics. So to qualify for this visa, you need to be someone who is one of a small percentage who has risen to the very top of the field in your profession. And we're going to talk a little bit more on the next slide about kind of how you go about proving that you are one of the people that meets this criteria. The O-1A visa can be granted initially for 3 years, and then you can either, renew in extensions of 1 year. Sometimes if there's kind of a new project you're working on, you can, renew for another 3 years. And there's kind of no limit. So like for an H-1B or an L-1, an H-1B you can have for 6 years, an L-1 you can have for 7 years, and L-1B you can have for 5 years. For the O-1 visa, you can kind of continue to renew this indefinitely. There's no limit in that same way. So let's talk about the O-1B visa. So this is, similar to the O-1A. It's a temporary visa that is for individuals who have extraordinary ability in the arts, also in motion picture or the television industry. So there's a different and slightly lower standard to meet the O-1B criteria. And this is rather than kind of having risen to the very top of your field, you have to have show that you've received distinction. So this is a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So, when you're looking at kind of O-1A or O-1B, there are certain categories that sometimes you can argue for one or the other. So sometimes the O-1B can be a bit more favorable because it does have the slightly lower standard of distinction. So then let's look at an extraordinary ability green card. Very often if someone comes over on an O-1, perhaps they're here in the US working for many years, and then they decide I'd like to transition and live in the US permanently, and I'd like to get a green card. So very often then the green card category they're going to examine is the EB-1A. And this is very similar in terms of the criteria, in terms of the documents that you need to provide. Again, it's appropriate for individuals with extraordinary ability. And this is for either arts or for people in science, education, business, or athletics. I'd say the standard, though, is very high. So when we look at, if we consider kind of O-1B as distinction, O-1A is, someone who's risen to the very top of their field. The EB-1A has kind of similar language. So it needs to be someone who's risen to the very top of their field. But in order to get the green card, you do need to show substantially, more documentation to show extraordinary ability. So just because you have an O-1A or an O-1B does not mean that you're automatically going to be granted an EB-1A, because the standard of evidence is higher. And what they'll look for, if they're going to grant you a permanent visa, so you can live in the United States long-term and eventually become a US citizen if you so choose, that standard is just going to be higher. For all three categories, you kind of need to show evidence that you either for the O-1A or O-1B that you actively have work for the time period you're trying to get the visa for, or for the EB-1A, you have to show that you will continue working in your area of extraordinary ability after you get your green card. So let's turn to the O-1A and talk a little bit more about this particular visa. So the O-1A, to get this visa, you need to show either that you've received kind of one major nationally or internationally recognized award, so like a Nobel Prize, a Pulitzer Prize, or much more commonly for most applicants, you're going to show that you have evidence of at least 3 of the following, ideally as many as possible. So looking at, receipt of nationally or internationally recognized prizes or awards. So these are the types of things where, like, if you're in university and you won lots of, prizes as a student, those usually aren't going to be the most helpful for your case. It really should be, prizes or awards that are given out by very prestigious organizations. You want to just show not just that you won the award, but that the institution granting the award has a very high standard for who they give out these awards to in your field of expertise. So another, membership in associations in your field, which require outstanding achievement. So again, it's not the type of thing where, you're in a professional association and you pay a yearly fee and you can attend the conferences. You really want to be looking for the types of memberships where there's a very high standard for who's allowed in. Perhaps you have to have reached a certain level in your field, that you have other people that are members of the association that have, accomplished great things in the field. All of those are helpful, when submitting this documentation. So another, published material in professional or major trade publications, newspapers, or other major media about you and your work in the field. So again, this is showing that you are someone who's made an impact in your industry, that there's interest in you, and that it's not just from a local newspaper or something like that, but really from kind of places, kind of media that have a real, like, far-reaching impact in the field. So it may not be that it's major, it may not be the New York Times or the Wall Street Journal, but if it's a very highly ranked publication in your particular industry, then that can be very, very helpful. So another is original scientific, scholarly, or business-related contributions of major significance in your field. So, things like patents, anything that you can show. If you can show that you're really a thought leader in your field, perhaps you've been invited to give, multiple keynote speeches at kind of the top conferences in your industry. Those types of things that indicate that really you are at the forefront of what's happening in this industry is, very important. Authorship of scholarly articles in professional journals or major media in the field. So, some industries lend themselves to this more than others. There are some fields where kind of having a high number of citations, having a high number of publications is going to be very important, because that's how the field shows prestige. And then there's others where that's really not the case. There's been kind of changes to the USCIS policy manual that have kind of indicated some of the alternate evidence that you can offer when your field is not the type that lends itself to publications, as not all, industries do that. Perhaps if you're an entrepreneur and you're someone who's, received a significant amount of venture capital funding, or you've had, very large companies reach out to you and want to use your product, things like that can also stand in other areas, so the fact, I think it's very common that we get people contacting us and saying, well, I'm very accomplished, I have this, I have that, but I've never written any articles. And just because that's something that many fields use, and just because in certain areas, that may be an important metric. It's not really an important metric for every field. So you do want to kind of think about your industry and where is it that it really makes sense for you to provide this documentation. So then another criteria is high salary or other remuneration for services. So here's where you're going to want to really define your field. What are the high salaries within your field, where you in particular are working, and then, comparing to that, do you have a high salary? So another, criteria, participation on a panel or individually as a judge of the work of others. So again, this is relevant in some industries, not as relevant in others. It can kind of take different, like, for example, if you're, doing a peer review for a scholarly journal in some industries, that's very important. In other industries, you would never see something like that. So it's important always to kind of talk through with your lawyer what makes somebody accomplished in your industry. How does your industry recognize accomplishment? And then can you match that to any of these criteria for O-1A? And then last, employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. So I think this one can often apply to most, most O-1A applicants if they have had a significant work history working for, organizations with distinguished reputations and have that kind of high level role within that company. So you don't need to meet all of these, only 3. It is helpful, of course, to include, as much as you can. And we'll talk a little bit more in a future slide about this, but it's not just that you say, well, I've had some prizes, here's proof of some prizes, here's proof of some memberships, here's proof I've judged some panels, I automatically get approved. That's not the way that it works. You have to, they'll kind of do a 2-part analysis. So first they'll see, have you met the, the actual regulatory criteria? So do we have some proof that you've won prizes? And then they'll look to see, does this show that you are someone who has risen to the very top of your field? So if you've won a prize, but it was from your, your university, that may not be something that shows that you've risen to the very top of your field. If you've won a prize and it was from, one of the Google Labs, top, competitions for the year, that would have a lot more impact. So you always want to think about that when you're putting the documentation together. You don't want to just submit, not all documentation is necessarily helpful. So you always want to kind of work with your attorney to figure out what is actually going to help me, show that I am someone who's risen to the very top of my field. Perhaps including all the proof of my student awards will not be helpful. So you always want to be strategic about that. Let's talk a bit about O-1B. So for the O-1B visa, so this is for the arts, kind of follows a similar structure in terms of how you prove that you meet these requirements. So either you've been, nominated or received a significant national or international award, an Emmy, a Grammy, or evidence of at least, 3 of the following. So, have you, performed a lead or starring role in productions or events with distinguished reputation, critical reviews or other published material, evidence of performance in a lead starring or critical role for organizations. So, I'm not going to kind of go through each one the way that I did with the O-1A, but what I'll say is, for each of these, and you can see there's some crossover, but it's much more geared, towards the arts, towards motion picture and television. For each of these, in the same way as O-1A, for O-1B, you also need to be thinking about not only kind of, do I have the proof that I've met this criteria, but is it from a, an organization, or is it showing that I actually am someone who has achieved distinction in my field, above that's ordinarily encountered. So this is, always when you're thinking about putting together your evidence, you want to just look at each of the regulatory criteria, write down kind of what you might be able to pull out from your history for each of these, and then determine, are the places from which I've received these awards or the places that I performed, are they prestigious enough? Does it show that I am someone that has risen to the top of my field, or someone who's achieved distinction, beyond just meeting the criteria of, I performed a starring role. Let's move to differences between the O-1A and O-1B. So, as we kind of talked about, O-1A is for science, education, business, or athletics. For O-1B, it's arts and motion picture or the television industry. The standard for O-1A is higher. It's one of a small percentage who've risen to the very top of your field. And then for the arts, high level of achievement. and for motion picture, a level of acclaim substantially above that of his or her peers. So you want to make sure that you are, considering those. As I said, there's some flexibility sometimes between whether you can choose O1A or O1B. Sometimes there's kind of categories that don't neatly fit. For example, kind of mixologist, cocktail mixologist is something that kind of arguably could fall into that arts, criteria, arguably could fall into business. So there is kind of some ability to be strategic about what you choose sometimes, if you have a category that doesn't neatly fit into one or the other. Let's look at some other, similarities between them or differences. So for how long they're issued, it's the same. You can get your initial visa for 3 years. You can get extensions for 1 year. If you're starting a new project or a new series of projects, a new itinerary, sometimes you can get, a new grant of 3 years as opposed to just a 1-year extension. In terms of whether your family can come to the US, the answer is yes. Your spouse and your dependent children, so that means children who are unmarried and under 21 years of age, can accompany you. Your spouse cannot work, your child cannot work, but they can, both be in the United States with you and also attend school with you, or attend school. All right, so let's talk a little bit about, the EB-1A green card. So the EB-1A, the actual requirements are very similar to the O-1A and O-1B. So receipt of a major award or meeting 3 out of 10 criteria. Although of course you want to submit for as many criteria as you can. For the EB-1A though, there's a specific analysis called the Kazarian analysis. And this is something that they also, USCIS has also generally started applying to the O1A and O1B categories, but the case law is focused on this green card category. So what they'll do is they do a step 1 analysis where they'll look at the evidence to see if have you won that major award? Do you have 3 out of the 10 criteria? But that's not where they stop. At that point, they're going to consider the quality of your evidence. So, that's where we're looking at, have you submitted proof of that you won a dozen prizes, but each of these prizes was given out by an organization that doesn't really have a very established reputation. If that's the case, it's really not going to make for the strongest, strongest application. It would be much better to submit with perhaps 2 major awards from, kind of the most major, let's say, media organizations working in your field. So you really do need to think about kind of what is the quality of the evidence that you're submitting. And often in these petitions, they can be hundreds or even thousands of pages. And you want to think about how can you make it as clear as possible to the officer that the quality of what you're submitting is very high. And so it is important to kind of not just say, well, I've won these awards or I've published these papers, but consider what organizations have I won these awards from? Where have I published, these papers? What types of media personalities are reaching out to me about my work? Am I someone who's been invited to speak at conferences, and are those conferences kind of the top conferences within my field? So those are really the questions you want to be asking as you're pulling together the documentation. For the EB-1A, there's a large benefit that you do get a green card. So if you can demonstrate that you meet this criteria, you would be able to get a 10-year green card and then stay in the United States indefinitely and live and work here. You would need to kind of put into your application that you do plan to continue to work in your field of endeavor. A large other benefit of the EB-1A is that you can self-petition. So for many, many green card categories in the employment-based sphere, you have to have an employer, a U.S. employer who's sponsoring you. That's not the case for an EB-1A. As long as you submit a statement or other proof showing that you plan to work in your field of endeavor and you meet these criteria, you can, work in the United States and really work anywhere. You're not limited to working for any particular employer in the United States, which I think is a very big benefit of the EB-1A. So what we'll do now is we're going to switch gears a little bit to start talking about the National Interest Waiver, which is another great option sometimes for people that haven't quite met the EB-1A standard, but maybe, could meet this criteria. So I'm going to turn it over to our Senior Associate GA to talk us through that.
All right, thanks, Kelly. So yeah, let's talk about the National Interest Waiver green card. So the NIW is a subset of the EB-2 green card category, but the difference with normal EB-2 employer-based green card is that you don't need a U.S. employer to sponsor you. If you qualify for the NIW, you can self-petition for a green card. All right, so what requirements do you need to meet to qualify under the EB-2 National Interest Waiver green card category? So first, you do need to show that you can meet the EB-2 threshold requirement, right? So there are two ways where you can meet this threshold. The first way is by showing that you have an advanced degree, which is defined as a master's or above. So for example, a PhD would qualify, a JD would qualify, an MD would qualify because it requires a bachelor's to get to that level, or the equivalent of an advanced degree. So for example, if you have a bachelor's degree in chemistry, and if you have 5 years of progressive work experience after you received your bachelor's in chemistry, and progressive means, changing in terms of duties and title and salary, for example, changing in terms of increasing seniority of these duties. If you have that 5 years of progressive work experience, you can show that you can your bachelor's degree and your related work experience combined to become the equivalent of a master's in your field. So that is another way you can meet the advanced degree requirement. Another way you can meet the EB-2 threshold is by showing exceptional ability in the sciences, arts, or business. So then how do you show that you have exceptional ability? And keep in mind that you do not need to go into the exceptional ability analysis if you already do have an advanced degree. So this is only applicable if you, for example, if you only have a bachelor's and if you have 2 to 3 years of experience, so you can't be considered as having an equivalent of a master's degree, or if you have no bachelor's degree at all. Exceptional ability can be relevant in those circumstances. So in order to show exceptional ability, you first need to provide evidence meeting at least 3 out of the 7 criteria listed here. And this includes things like 10 years of full-time work experience in your field, proven by letters on company letterhead from your previous employers, verifying the terms of service. Also, another criteria you can rely on is high salary. If you earn a higher salary than most other professionals in your field, that can show exceptional ability that you're performing at a level that is significantly higher than what is ordinarily encountered. Another type of evidence you can include is evidence of recognition for your achievements by your peers, the industry, government actors, etc. This can be shown through original intellectual property, such as patents or papers. It can also be shown through awards. So really many different evidences of your professional achievements that is outstanding in the field you can use to potentially meet this criteria. Holistically, the body of the evidence that you have must show that you do have a degree of expertise that is significantly above what is ordinarily encountered in the field. And it is worth noting here that the criteria, the standard for exceptional ability is lower than the standard that you would see in EB-1A petitions, for example, which is defined as extraordinary ability. Extraordinary ability really is defined as that you have reached the very, very top of your field, and you're known as one of the small percentage that has reached that top. However, the standard for exceptional ability is significantly lower than that. You just need to show your performance is at a level that is above what is ordinarily encountered. So now let's say you do have evidence meeting the threshold for the EB-2. The next step, and really the core of the NIW application, is demonstrating that you qualify for the NIW. And to show that you actually qualify for the NIW, you need to provide evidence under 3 prongs that is promulgated by a case law called Matter of Denizar, right? So the first prong is that your proposed endeavor in the U.S. should have substantial merit and national importance. So what does this mean? Substantial merit can be shown in a wide variety of fields, including business, health, education, science, technology, and endeavors that further human knowledge in these key areas, such as medical advances, civil engineering, environmental sustainability. All of these endeavors, if you can show that they have potential to improve the field, you can show that that your endeavor has substantial merit. Endeavors that have the potential of giving strong economic positive impacts to the U.S. or a specific region, that could also be very helpful in proving substantial merit and national importance. So really the key question to ask here is, what is the prospective future impact of my work, and how is this important to the United States? So that is a question that you can ask yourself on how to frame your proposed endeavor to make a persuasive case that your work in the United States holds substantial merit and national importance. And in supporting this, it is also a high recommendation to compile objective third-party evidence showing the importance of your work. So, for example, government reports, executive orders, for example, showing that the government is making an investment in a certain area, for example, strengthening supply chains, or environmental sustainability, or civil rights, or things like that. You can bring in those third-party reports to really bolster your argument that your work will have this impact that is important to the United States. Now, the second prong of the matter of Danazar test is showing that you yourself are well positioned to advance the endeavor. And what does this mean? It means that your education, skills, and relevant experience and record of success in your field of endeavor positions you well to continue doing this work, which has substantial merit and national importance. So you can prove this by, for example, persuasive expert letters that talk about some of the projects that you have led in the past that led to impacting the field for the better, for example. And those case studies can support that you have the relevant skills and experiences to continue having those positive impacts for your future endeavor. Now, the third matter of Danazar prong in qualifying for a national interest waiver is that to show that on balance, it would be beneficial to the United States to waive the requirements of a labor certification in your particular case. For example, in the case of entrepreneurs, right, the ordinary policy for Congress in having the labor certification requirement is to protect the U.S. labor supply, such that foreigners cannot take away a job position that could be made available for U.S. people. However, there's a countervailing benefit to having entrepreneurs come into the United States if their business endeavor will create a high number of jobs, for example, right? So actually Congress's policy of protecting the U.S. labor supply would be better served by having the entrepreneur come in and do this work and produce those additional jobs. So there are a variety of ways we can argue on how, on balance, granting the NIW would actually be of benefit to the United States compared to the countervailing benefits of normally following through with the labor certification requirement. All right, let's see. So what is included in expert opinion letters? So it is worthwhile to sort of go over what the expert opinion letters play in terms of the role in an NIW application, because the NIW is a very narrative-driven category. The government expects to see an explanation of why, what the impact of someone's work will be and why it is of national interest. So what would those expert opinion letters talk about? So in terms of the NIW, expert opinion letters would either talk about the national importance of the proposed endeavor, or the letters would talk about the applicant's contributions in the field for previous projects that they have completed. And this would support how they are well positioned to advance the endeavor. O-1s and EB-1A petitions also rely on a large part on expert letters. For example, if we're trying to show that if we're trying to show that an O-1 or EB-1A applicant is famous, well-known in the field for their original contributions to the field, we would want the expert letters to come in and talk about what these original contributions were, what industry-wide problem it solved, and what the results of this contribution was. So what is also important is who is writing the letter. And typically those letters would include information on the background of the letter writer. We will want to submit letters from individuals who are already well known in the industry, who have very impressive resumes, such that USCIS can trust the opinions of that letter writer because they already have those stellar credentials in the field. You can also submit letters from your senior, if you're an applicant, current employer, past employers who actually know the work product of the applicant and can talk in detail about what the impact of those past projects have been. And as I mentioned before, a detailed discussion of the work that the applicant has done, including how this work impacted the field as a whole, and also how this achievement sets them apart from others ordinarily performing in the industry. That would be a key to supporting a strong EB-1, O-1, or an NIW case. And it is very important in this endeavor to be as specific as possible with the examples that you include in those expert letters. All right, so how would you then decide which categories should you apply for? We have discussed a variety of categories. We have discussed the O-1 categories, the EB-1, and the NIW. So one consideration here is your plans on staying in the United States. So people may have different needs in terms of traveling abroad, back and forth between their home country and the US. So if you foresee that you will really be spending a lot of time outside of the United States, the O-1A and O-1B may be a better option for you because these ones are non-immigrant temporary visas. If you go for the EB-1A or the NIW, those will end up in a green card. And really, the green card is most advantageous for people who intend to live in the United States permanently. If you get a green card, but then you stay too long outside of the United States, you can end up losing the green card and things like that. So you really want to make sure that your future plans are aligned with the expectations for the visa. Now, another consideration that can impact which category you would go for is, do you have a U.S. employer or agent who can act as the petitioner sponsor of your petition? So the O-1A and O-1B does require a U.S. person, either a U.S. organization or a U.S. agent, a U.S. person who is an agent, to act as the petitioner for your case. And actually here, it is important to mention that if you are an entrepreneur and if you set up a company that you own 100%, actually, though, that has been okay in terms of using that company as the petitioner for your O-1A petition. So there can be a variety of different strategies to secure this U.S. petitioner. But for the EB-1A and NIW, there is no requirement for that. So both the EB-1A and NIW allows the applicant to self-petition for their green card. So if you do not have any connection to the United States for an organization or an individual who can act as the petitioner, the EB-1A or NIW could be a good option for you. Now let's talk a little bit about family, right? So for O-1A, O-1B, spouses and minor children, unmarried and under the age of 21, can join you with a dependent visa O3. However, but the spouse who joins you cannot work in the United States. So the O3 visa does not give work authorization for the spouse. However, this is different for the EB-1A and NIW because the end result of the EB-1A and NIW is a green card, which means your dependents can join your petition as beneficiaries for the green card. And at the end of the process, they will also become green card holders, which gives them considerably more freedom if the goal is to stay permanently in the United States, to live and work permanently in the United States. Okay. So now let's move on. Considerations when moving from a non-immigrant visa to a green card. So this is an important topic to cover, and especially because we do see cases where someone who is already on in the United States on an O-1 visa would one day want to, their plans may change, and if they want to stay permanently in the United States, they may want to transition to a green card either through the NIW or through the EB-1A. Now, one thing to note here is that the EB-1A, although the criteria are described in very similar language with the O-1A criteria, extraordinary ability, the level of scrutiny that USCIS has for these two different categories, the EB-1A and the O-1, are very different. And that is just to note here that just by being approved for the O-1A, O-1B doesn't mean that that person will automatically be approved for the EB-1A. And typically a much higher level of achievement of a claim, sustained acclaim in the field is usually expected to get from the O-1A level to the EB-1A level. Another issue that could be important is timing. So take a look at your underlying visa. If you are in the United States on a different underlying status, on O-1, for example, you need to take into account when do I want to file? When does my non-immigrant visa end? And if you need to renew your visa in particular, for example, and this can be a more pronounced consideration for certain types of visa categories compared to other types. For example, the TN visa is a visa category in which the non-immigrant intent is very strictly scrutinized. So if you need to extend that visa soon after, then it may be beneficial to wait until you do have the extension before you file an I-140 for the NIW or the EB-1A, because those types of visas are harder to extend or renew once you have filed an immigrant petition, even with just the I-140 that can pose some risk. So definitely speak to your attorney if you are already in a non-immigrant visa and you plan to extend it, but you also want to apply for a green card. The timing of this could be very important. And finally, family considerations can also come into play. So for example, if you have children who may be aging out, reaching the age of 21 soon, it may be beneficial to make sure that you allow enough time to process and get the immigrant visa petition approved, such that your children can benefit from the green card as dependents before they age out. All right, so the last topic that we would cover today is, are extraordinary ability categories available for entrepreneurs? And the answer to this question is yes. Both the EB-1A and NIW allow for self-petitions, so it is possible for entrepreneurs to go ahead and apply for a green card, even if they do not have an external third-party U.S. employer to sponsor their petition. So this can be a very good option for entrepreneurs. For the O-1A, you do need a U.S. company to act as the petitioner for your case. However, as I mentioned before, if you are an entrepreneur and if you have a U.S. entity and you own the U.S. entity, that is okay. You can use that U.S. entity to act as the petitioner. So the O-1A is also an option for an entrepreneur. With the matter of Dennis case, which came down in 2016, there has been changes to the NIW standard. And in 2022, the USCIS also made some updates to the USCIS policy manual, which provided some alternative categories, alternative evidences that entrepreneurs could rely on to support that their work is of national importance, they're well positioned to advance the endeavor, and on balance, it is beneficial to the United States to grant the NIW to the entrepreneurs. So there has certainly been some positive changes in that regard, such that the NIW category has become a little bit more friendly to entrepreneurs. For example, just to talk about a few, if an entrepreneur can get letters from investors or users talking about their product or approach and its potential. If the entrepreneur can submit evidences of a history of hiring, revenue growth, job creation. Another example is if the entrepreneur can show proof of participation in prestigious incubators, accelerators, and a history of being awarded third-party investments from venture capital firms, that those can also be very helpful evidences to support an EB-2 NIW case. Yeah, and I believe that's all of the content that we had prepared so far for you. And I believe we do have a number of questions that came in, so we can look at those. First question, I'm more interested in EB-1A NIW. Do you offer free consultation to review eligibility? We do not offer free consultations. However, we do offer 30-minute consultations, which I believe is half the price. Is it $150, Kelly?
So yeah, if you have any interest in consultations, I think there's a couple of questions about that, about contacting us for consultations. So there is a link actually available on the PowerPoint that you can use to schedule a consultation, 30 minutes or 1 hour, and the pricing is available, once you go to schedule. I would also encourage you to check out many of our free resources. We do free webinars, and we also have a very active blog and a YouTube channel, which provide many, various insights along with the consult. But I think there was another question here about, asking about talking to the legal team. If you'd like to do that, please do use the link and schedule a consultation. We'd be happy to speak with you.
Great. I think there was a question with regards to I think it was the O-1A or EB-1A criteria. Do you need to meet all of the criteria, or is anyone is fine? For that one, you do need to meet at least 3 out of the various criterias that we explained. And even after you meet the 3 criteria, you do need to show that holistically you have received the level of a claim that is substantial, as required by the O-1 and EB-1A requirements. So there is also a 2-part test that you will need to meet. Okay, applying in O-1A, how much time it will take for getting a green card? So getting the timing for getting the O-1A visa is different than the timing for getting a green card, and the timing for getting a green card will depend on which category you would apply under, either the NIW or the EB-1A. I do encourage you to check out our other resources that go into more detail about those visas if you're interested. Okay.
So there's a few comments here just kind of on like the issues, with kind of the backlog and EB-2 and EB-1, and it definitely is a frustrating situation, in terms of kind of changing any of those requirements. That's very unlikely at this point, as it would require comprehensive immigration reform, which is likely not on the table anytime soon. In terms of whether there is someone's asking about minimum citation number. So there is not a minimum citation number. It's as kind of we've discussed under the Kazarian analysis, they're going to first look at, do you meet the criteria on the face of the language? And then secondly, holistically, like, do you meet the criteria, showing that you have risen to the very top of your field, for EB-1B, so it's something where it's not possible to just provide a number. It's something where we'd have to assess the case holistically, and that can be done also during a consultation. Someone's asking here whether an EB-2 NIW child under 21 can apply for work authorization. If you get to the point where you're able to file what's called an I-485 adjustment of status in the United States, for yourself and your spouse and children, then yes, as part of the adjustment of status application, your child can file for work authorization. At this point in time, EB-2 is backlogged for everybody, all around the world. So it's not possible to do that at this point. But if you get to the point where you're able to file an I-485, then yes. Someone's asked about what is matter of Danisar. So this is a very important case that changed the standard for the National Interest Waiver and made it much friendlier to entrepreneurs specifically, but also to all, I'd say, industries. We do offer free webinars specifically on the National Interest Waiver that go into matter of Danisar in quite a bit of detail. So I would encourage you to check out those webinars as well. I think these are questions that we've already answered. So we will close there. GA, thank you so much for sharing your knowledge. It was very, very interesting, lots of content, and thank everyone for your participation and for your questions. Have a nice day.
Thank you, everyone. Bye.